Hi, I'm Alex and I'm here with another video on high conflict child custody. This video is going to be on ex parte filings. So normally in court, the process goes pretty much like this. You file something or your ex does. Your ex files a response to whatever you filed, or you file a response to whatever it is they filed. And then sometimes there's a reply to that, sometimes there's not. The point is that the court is going to get briefed by both of you in writing and at a hearing. Sometimes there's a hearing, not always. So that the court can hear both sides of the story and make a decision based on what it's hearing from both sides. An ex parte filing is, or an ex parte hearing, you can work both ways, is basically the court hearing only one side of the story. And these are extremely popular in child custody litigation. Even I have used them, and they don't actually work. Most of the time they get denied. So I figured I was going to have to do a video on this to explain to people when it is appropriate to use ex parte filings, because from what I understand, they're actually extremely annoying to the court just because so many people file them and they're just not using them the right way. So to use an ex parte filing, you typically have to have a case where you're telling the court that you need a decision as soon as possible, and you specifically want the court to make its decision without hearing your ex's side of the story. There's two types of ex parte filings. There's one type which is just basically that you need a really quick decision and there's no time, in which case you still need to notify your ex of the filing. In the Nevada Rules of Civil Procedure, there's instructions on how to do this. I believe you're supposed to use any and every way possible, email, fax, have it dropped off just to let them know what you're filing. And you submit it immediately for decision, even though the other party hasn't responded yet. And the other type of ex parte filing is the type where you're basically telling the court that you can't let your ex know what you're asking for, because if you do, it would defeat the purpose of the motion. One common example of this would be in divorce actions, where you need to have both parties basically restrained from taking on new debts and such. I believe it's some kind of financial restraining order that just outlines that the parties are supposed to understand that they're now in a divorce action and they're not to be taking on more debt, no more community debt and stuff like that. And of course to not hide or sell off assets and stuff. In such a case, you could imagine a situation where you file a motion asking the court to do that, and then your ex reads your motion and starts to suddenly sell off assets, cars or whatever, or they start to just take on tons of debt. So yes, you don't want your ex to know that you're asking the court for this, so of course you would do that ex parte, and those are pretty common, and I believe those are granted routinely. In child custody matters, the issue I usually hear is my ex is emotionally abusing my kid, or something along those lines, and they say, it is an emergency. I understand that people feel, I used to feel that way, and I filed ex partes for my son too. But the problem is, so many people use them all the time that the judges just don't know who to believe anymore. So unless you have convincing evidence that your ex is in jail like right now because they stabbed your kid or something that's serious, that's that cut and dry, you really don't want to use the ex parte process to get an order. I know what I'm starting to think is it's a psychological issue. I think that what people want is so strong and so urgent that it outweighs what they realize they can get, and so somehow the power of wanting something so bad is going to make it work. Trust me, it doesn't make it work. Your motion's going to get denied, and you're just going to irritate the court. So, in rare cases, these can be used when there's a clear-cut issue, and the court has to make a decision right now, or basically going to court 2 months later, it's not going to help, because whatever issue you have is pretty much already resolved. It's already too late. So I'm going to give you one example where I did this and it worked. It was for a friend. She and her ex had a child custody dispute going, and the ex suddenly emailed her saying he was moving to Carson City and he was going to homeschool the kids. So out of the blue, he sent her an email saying the kids were now withdrawn from school, that they were moving to Carson City, and that they were going to start homeschooling. In this case, we were able to do an ex parte filing because she was able to cite a county regulation that stated if kids didn't go to public school for 10 days out of the year, then they were supposed to be expelled. So she was able to show the court the email. so that she could show the court what her ex was doing, his reasons behind it, and a county regulation showing that if the kids didn't go back to school, if they had 10 absences, they would be expelled. And this is a situation where the court can't hear both sides of the story, because in hearing both sides of the story, that's going to take several weeks, to file the briefings, and then the court would have to set a hearing, which could take months. And then once the hearing happens, by then the kids have already been absent too many times, and so they would have been expelled from school. So this is one of the cases where it worked. The judge read the ex parte motion, and he granted it. He actually did some kind of emergency telephonic conference, and everything was sorted out. But these are the kinds of situations where you should use it. If you think your child is being, emotionally abused, then you're going to just have to do it through the ordinary process, and you're going to have to ask the court to, consider psychological testimony or even appointing a psychologist. And you're just not going to be able to do this really quickly. And I also think that this comes down to another psychological issue, is that a lot of parents, including me, I was one of them, they don't like the idea of something taking a really long time to resolve, especially in the court system. And so there's this frantic search for an immediate fix right now, and it just doesn't work that way. And if you think of resolving your issues that way through the court system, you're not going to get anywhere, because you're going to file something, and then you're going to be upset that it doesn't get resolved, and you aren't going to realize that this is going to take 2 or 3 steps, 2 or 3 different hearings. You're not thinking so far enough ahead to where you start to understand that when you're going up against a high conflict child custody type of person, every move sometimes is a small piece of a larger puzzle. And if you get so bent out of shape in the fact that something can't be done right now, really quickly at one hearing, you're gonna end up just really getting nowhere. You're gonna be spinning your wheels. You're gonna go to court 3 or 4 or 5 times, just like you would have had to anyway. But because you didn't plan out from the beginning that you were going to end up going back to court 3 or 4 or 5 times, you won't have, put yourself in a situation where you could have used some of your, earlier motions or efforts to support or buttress some of your later motions and efforts. You can't go through the court process just thinking about today and the hearing and the dispute that's in front of you now. If you're up against a high conflict child custody person, you have to embrace that it's going to take multiple hearings, a long time, and a thorough process. Because the sooner you embrace that, and the sooner you start to plan for that, the sooner you start to have real success. I did 2 or 3 ex parte filings. All of them were denied. And I didn't start to have any success until I started to embrace the fact that every dispute I was having, I was going to need to think to the future. And by doing so, when future disputes came up, I had planned the situation. I had laid out the facts in a way that helped me ultimately win. So going back to the general principle is ex parte filings, don't use them. It may work great in real life when you're talking to coworkers and friends and family, and you're telling them your side of the story about whatever horrible thing you're going through, and they take your side. It's not how the court system works. The court system wants to hear both sides of the story before they make a decision. Except in rare circumstances, and you're going to have to look at court rules and statutes, because ex parte filings can be governed in widely various ways between the states and the federal system. So I'm not going to go into any specifics, because they could also frequently change. Again, the general principle, avoid ex parte filings if at all possible. And if you have any questions, you can look into some of my filings. I have them online, and I'll post the links down below. And that'll be the end of this video.